judgment of this court, and 150 million naira only as general, exemplary, and aggravated damages for the permanent physical disability suffered by the claimant in the course of his duty as a staff of the first defendant, pain, suffering, anguish, and the lawful termination of the claimant's appointment in the first defendant company. 100 million naira for defamation, assault, disrepute, and degradation of the claimant by the first defendant. The claimant predicated his claim on the statement of fact and witness statement of oath, respectively, filed on the 4th November 2015 and 29 October 2018, and reply and further witness statement of oath filed on 29th October 2018. The defendants jointly based their defense on the amended statement of defense, witness deposition of oath filed on the first day of July 2019. At the preliminary trial on the 29th October 2018, the claimant who testified for himself, herein refers to as CW1, identified his depositions and additional witness statement of oath made after the close of the hearing of the suit on the 3rd day of October 2023, the matter came up for adoption of final written address filed by counsel. Counsel for the defendants identified his final written address filed on the 13th January 2023 and reply on points of law filed on the 17th day of July 2023 and adopted same as his legal submission in the aid of the case of the defendants and urged this court to dismiss the suit. The claimant was not represented for the adoption of final written address. This court, pursuant to the 45(7) of the rules of this court, adopted the final written address file on behalf of the claimant on the 5th day of April 2023. The claimant stated that the claimant was employed by the first defendant company sometime in January 2008. Upon his employment, the claimant carried out all given tasks in the first defendant to the best of his ability and utmost skill and diligence. That on the 2nd day of October 2008, the claimant was working as a field staff at Alu site of the first dependent company. While doing his work on the 2nd day of October, he was instructed by Mr. Ade, the site engineer and expatriate, to undertake the cleaning of one of the asphalt plant machines of the first dependent company, which is used to sift and filter dirt from the asphalt. And the claimant, being a field staff, protested that he had no experience and requisite training on how to undertake the cleaning of the said asphalt plant and had not undertaken the cleaning of the said machine ever before. Mr. Ade told the claimant that he would be sacked if he refused to clean the asphalt plant. The claimant, being a field staff, was owed a duty to have been taught the necessary and safety ways to clean such a hazardous machine. But the first defendant company that owed him that duty through its official, especially the sixth defendant, neglected to do so, thereby jeopardizing the claimant's safety and exposing him to extreme danger. That normally the asphalt plant used to be cleaned by the plant operator, who is especially trained in the handling or operating the cleaning of the said asphalt plant. When any machine, whether production or otherwise, is to be cleaned, it is usually put off to ensure the safety of the cleaning personnel and those in the immediate environment. That on a fateful day, the claimant, while carrying out Mr. Ade directives to clean the asphalt plant, requested the engineer to put up the plant in preparation to its cleaning. when the sixth defendant, the site engineer, ordered him to leave it on and run so as to ensure that the interior part of the machine is properly cleaned, even though he was aware that the claimant was never given any training on the cleaning of the said plant or any other plant, as the claimant is a laborer, not a plant operator, and had never cleaned the said plant before that date. And the claimant protested this directive of the sixth defendant as it was contrary to safety rules and precaution, but he was again threatened to be sacked if he disobeyed the directive of the sixth defendant. Out of fear for his job in the face of the prevalent unemployment rate in the country and the crunching economy, bearing in mind that he is the breadwinner of his family, the claimant carried out the orders of the sixth defendant while the claimant climbed atop the asphalt plant and was cleaning the plant. His right foot slipped into the grinding interior of the plant, and he slipped into the plant. That because the plant was on running, it grinded the claimant's foot, chopped off fragments of his flesh, permanently disabled his foot, and incapacitated him. The claimant screamed due to pain and massive bleeding. Luckily for the claimant, he was discovered by one of his co-workers. He was rushed immediately to Teme Hospital, Mile 1, Diogu, Port Harcourt, Rivers State. And the claimant was left with the gory side part of his right foot, having been eaten or grinded away by the first defendant production machine, and his feet was torn into a gory side of blood and smashed flesh by the production machine. The claimant also lost a lot of blood. The claimant was admitted in the Teme Hospital, Port Harcourt, from 2nd of October 2008 to 7th day of October 2008, wherein he was receiving treatment paid for by the first defendant. That on the 7th day of October 2008, the claimant was discharged from the hospital and was placed on crutches with the instruction for the first defendant to bring him to the hospital for checkup and dressing of the wound regularly, from then on as an outpatient. The first defendant company for a while and abandoned the claimant in his incapacitation. The claimant was instructed by the Teme Hospital my one day to ensure that the first defendant takes him for special surgery to remediate the permanent disability on his right foot, occasioning the first defendant asphalt plan due to the sixth defendant negligent official instruction, which was contrary to safety rules and precaution, as the said incapacitation will create an impediment to him both now and most especially in the future if not properly remedied. That although the claimant was being paid salary by the first dependent company for the time he was operating the hospital and at home, he was again threatened by the first defendant and told that the company will stop paying him salary if he did not report to work. The claimant had to go to the first defendant with his clutches and supported by family members in order to show that his injury had not healed and that the face of his injury had not sealed up. The first defendant officials then instructed the claimant to be reporting to his duty post, even if he does not do anything, so that his pay would be justified. The claimant, being the breadwinner of his family, agreed, even though he was still incapacitated. No efforts was made by the first defendant personnel to achieve the special surgery directed by the doctors to remediate the permanent disability on the claimant's foot, and nothing was being given to the claimant by the first defendant or any of the defendants to ensure his regular checkup in hospital. That when the claimant resumed at his duty post, he was asked to work night shift. That night, when the claimant went to take diesel to meet bitumen, he was confronted by one Oscar who asked him what he was doing in the place where diesel was kept, which the claimant replied to him that he was on duty. That to the utmost surprise of the claimant, the said Oscar went outside the gate and later returned with about 50 empty jerrycans and accused the claimant of attempting to steal the first defendant diesel in order to sell it. The said Oscar then raised alarm and started shouting, "Thief, thief," which was in the middle of the night. And the seventh defendant was then called, and he ordered the policemen and the security men to beat up the claimant mercilessly without hearing the claimant's side. The seventh defendant then said he was going to deal with the claimant, that he was beaten and he was hit with fist blow severally on his ear, which caused his vision to become blurred, and he bled from his nose and ears. And few days after the severe beatings, a smelly, watery substance started flowing out of his ear as a result of the beating, which indicated that he was bruised severely by the security men and policemen attached to the first defendant company. That while the claimant was being beaten, he pleaded with the seventh defendant to take the matter to police so that it might be resolved. But the seventh defendant refused and instead locked the gate of the first defendant against the claimant at that time of the night, alleging that he attempted stealing 6 jerry cans of diesel, knowing very well that it was a false allegation against him, that he was severely defamed and his person and character seriously damaged. That the first defendant, without hearing from him, went ahead to make a publication in the company that the claimant employment is terminated on the basis that he stole the said 6 jerry cans of diesel from the company's premises, that his employment in the first defendant was unlawfully and maliciously terminated, that he instructed his lawyer, Dr. Innocent Eku, to write to the defendants to redress his unlawful termination and failure to provide him with the necessary cash for his surgery, a regular checkup, but to no avail. That after the brutal beating of the claimant and the injury inflicted on him, went to University of Port Harcourt Teaching Hospital, where he was treated for the bruises he unjustly sustained in the hands of the security personnel of the first defendant. And he was also referred to ENT department of the hospital for adequate treatment for smelly colored water that his ear was emitting. That the claimant is a breadwinner of his family, and he has tried severally to secure employment in other companies to no avail, as all the companies rejected him due to the permanent disability which is on his right foot and does not enable him wear work boot or even sandals. That the claimant finally gained employment sometimes in 2010 in DOS company at Port Harcourt Airport, Amagua, as a laborer. That on the day the claimant was asked to resume work at the company, he resumed work with slippers on his feet because he cannot wear shoes. Whereupon the officials of the company instructed him to put on his work boots, which is one of the compulsory safety requirements for his type of job. That the claimant then showed the official of the company the permanent disability on his foot, which prevents him from wearing shoes or even sandals, as he can only wear loose slippers. That the officials of the company then informed the claimant that he would be dropped by the company as it would be impossible for him to adhere to the compulsory safety requirements, which includes wearing work boots and which is mandatory in his type of work. That he was told to leave the premises of the company due to his disability, and it is impossible for him to secure employment anywhere again. That he has remained without an employment since then, despite his efforts to find a job, and it is practically impossible for him to fend for himself or his family, even though he is the breadwinner of his family. That the claimant has remained without a job or means of livelihood ever since, and his health is seriously worsening due to the injury the claimant sustained in the course of obeying the official order of the sixth defendant in the first defendant company. The defense of the defendant is that the defendant stated that the claimant was verbally employed as a casual, non-skilled daily rate worker, sometimes in January 2008, to carry materials and machine parts at the asphalt production site, Alu. The terms of the employment were verbally agreed upon between the first defendant and the claimant.
That is to when I'm done. When they are
hospital from 2nd day of October 2008 to 7th day of October 2008, or any ailment or wound that warranted the claimant to attend the University of Port Harcourt Teaching Hospital was not caused by the defendants or any of them. The claimant was, however, suspected to have attempted stealing diesel by the security guard on duty in the said night. The claimant was caught with the 6 jerry cans. He was caught with the jerry cans by the security guard, and not that the guard brought the jerry cans with which he accused the claimant of attempted stealing of diesel. Nothing was done to the claimant by the suspicion, and his services were not terminated because of the suspicion, other than that his employment was no more needed by the first defendant. That the claimant was a daily paid worker, and for each day he was engaged by the first defendant to carry any material or equipment, he was paid until his employment was terminated lawfully. The defendants did not owe the claimant any unpaid salary. Also, the defendants are not liable to bear any financial burden involved in the purported surgery to be performed in the injured leg of the claimant. After the close of each party's case, the counsel for the claimant nominated 4 issues for the determination of the suit. To wit, whether determination of the claimant employment of the first defendant by the first defendant was unlawful for not following due process of law. And secondly, whether the termination of the claimant employment which did not comply with the due process of law, the claimant was entitled to his salaries and remuneration from the month of unlawful termination till the month of judgment, and whether the claimant has suffered permanent disability at place of work while on duty and is entitled to compensation, and having not been paid since 2008 till 2023 is entitled to general damages, exemplary damages, and aggravated damages for permanent disability, injury, pain, and sufferings. And fourthly, whether the false allegation of the first defendant and its officers that the claimant was caught stealing 250 liters of jerrycan for which he was beaten mercilessly and tortured before being handed over to the police, all in the ploy to terminate his employment, is defamatory, for which the claimant is entitled to compensation. Counsel for the defendants also nominated 4 issues for the determination of this suit, to which: 1, whether the claimant's suit is not statute barred given the facts of this case, and secondly, whether the termination of the claimant's employment was wrongful, and thirdly, whether the claimant is entitled to any monetary claims for assault and libel, and fourthly, whether the claimant should disclose reasonable cause of action against the defendants. I have carefully gone through the processes filed by the parties in respect of this suit. I am of the view that issue 1 and 2 raised by the claimant are the same, while issue 2 raised by the defendant subsumes issue 1 and 2 raised by the claimant. The defendants also raised the issue of jurisdiction. Even the claimant did not address same, but the court will definitely address same since it borders on jurisdiction. For these reasons, I will adopt issue 3 raised by the claimant and issue 2 raised by the defendants. For the avoidance of doubt, the issues for determination before this court, this suit are as follows. 1, whether this court has jurisdiction to entertain the suit. Secondly, whether the termination of the claimant's employment was wrongful. And thirdly, whether the claimant who has suffered permanent disability at place of work while on duty is entitled to compensation, having not been paid since 2008 till 2023, is entitled to general damages, exemplary damages, aggravated damages for permanent disability, injury, pain, and sufferings. I will skip your final written addresses. You know what you submitted. I will directly go to the court's decision. I have carefully considered the processes filed in this matter and all the issues raised by parties. On issue 1, which borders on the jurisdiction of this court to entertain this suit, it is not out of place to reiterate that jurisdiction is the power or competence of the court to entertain an action or an appeal brought before it. It is a threshold matter that is of utmost importance. For without it, a court cannot proceed to consider a case before it. And any proceedings conducted in absence of jurisdiction, including any decision reached, amount to a nullity, no matter how brilliantly conducted or rendered. Hence, any decision that hinges on the absence or presence of jurisdiction is of greatest importance to the sustainability of the action before the court. Jurisdiction is the blood that gives life to an action in the same very way that blood gives life to human being and the animal race. It is imperative that a court determines a challenge to its jurisdiction immediately it is raised in order to avoid embarking on an exercise in futility. It is due to the importance of the issue of jurisdiction that parties are permitted to raise it at any stage of proceedings, whether immediately when the suit is filed, at the stage of filing final written address, or even on appeal. A court may even raise the issue of jurisdiction soon. See the case of Beefy Industries Limited against OF Nigeria Limited, reported in 2023, 9 NWLR Part 1889 at page 279. By way of recap, may I start by saying that on the authorities of the old and famous case of Madukolo against Nkedi and the case of Attorney General of the Federation against Guardian Newspaper Limited, the competence of court in the exercise of its jurisdiction is determined by the following. If it is properly constituted with respect to the number and qualification of members, the subject matter of the action is within its jurisdiction, and the action is initiated by due process of law, and the condition to the exercise of jurisdiction has been fulfilled. For a court to be competent to assume jurisdiction of a matter, the outlying condition must be conjunctively fulfilled. One of these ingredients for the determination of jurisdiction rendered the court infertile to activate the jurisdiction of the court. Let me dissect and categorize the claim of the claimant from the introspective study of the statement of facts and the relief thought by the claimant therein. The claimant complains about the termination of his employment and seeks relief 1 and 2 thereof. Again, the claimant's relief 3 covered the alleged permanent physical disability the claimant suffered in the course of his duty as a member of staff of the first defendant. And relief 4 relates to the damages for tort of defamation and assault suffered by the claimant while in the employment of the first defendant. The complaint of the defendants is about liveness of this suit in general, and the propriety of this court in its own jurisdiction over defamation in particular. These 2 grounds of objection are tied to condiments of the jurisdiction itemized in B and D above. The defendant submitted that the claimant did not commence the instant action until 2015. Submit that the claimant's suit is statute barred for not being filed, for being filed outside the period permitted by the Rivers State Limitation Law 2004, which is 5 years, and the suit was filed 6 years after the cause of action arose. This suit was filed on the 4th day of November 2015, and the claimant stated in paragraph 34 of statement of fact that is employed of the first defendant when the defendant made a publication in the company that the employment of the claimant is terminated on the basis that the claimant stole 6 jerrycans of diesel from the first defendant. Though the claimant did not state the year and month his employment was terminated, but the claimant, that is CWN, stated under cross-examination that his employment with the first defendant was terminated on the 23rd day of August 2009, and by Section 16 of the Limitation of Law of Rivers State 2004, action founded on contract, tort, or any other action not specifically provided for in parts 1 and 2 thereof cannot be brought after the expiration of 5 years from the date of which the cause of action accrued. However, the National Industrial Court of Nigeria has been very consistent in its plethora of cases, which includes the decision in the suit number NICN LL 553-2018 between Mr. Godson Okechukwu Kume against First Bank of Nigeria, suit number NICN LH 408-2018, Lillian Inena Akuma against First Bank of Nigeria PLC, the judgment delivered by the president of this court, and a host of other cases. This decision was predicated on the Supreme Court case of National Revenue Mobilization Allocation, Fiscal Commission, and others against Ajibola Johnson and others, tracing a historical trajectory of case law authorities on this issue, especially emanating from the apex court of the law. One will see that they have oscillated from holding that the limitation law, including the Public Officers Protection Act, does not apply to contract of service. That is, should not be noted that employment contracts are contract of service. The problem here is that, except Honorable Justice Ariola's decision, the present Chief Justice of Nigeria, in the case of National Revenue Mobilization Allocation and Fiscal Commission and others against Ajibola Johnson and 10 others, very little attempt has been made to review the old authorities before arriving at the holding whether the limitation law applies to contract of service or not. The older cases that are over time acknowledge that contracts of service were not caught up by the limitation law include Salako against Lagos Environmental Development Board and another. For instance, in Ibekwe JSC, Reliance Salako will a Nigerian Post Authority act against Controzioni generally held that, and I quote, "We agree that the section applies to everything done or omitted or neglected to be done under the powers granted by the Act, but we are not prepared to give to the section the stress which it does not possess. We take the view that the section does not apply to cases of contract." At the National Industrial Court, we follow these older authorities in holding that the limitation law does not apply to labor rights, given the inequity and injustice of subjecting employees or workers to the vagaries of the limitation law. Then came the authority of Christiana Ayari against National Salaries and Wages Commission, where His Lordship Galadima JS held that, like, the Officers Protection Act is a status of limitation. It is exact as to time frame. It provides for 3 months, not a delay longer than 3 months. See Nwanko against Eradua, Ibrahim against JSC Kaduna State, all citation provided. The facts are in National Revenue Mobilization Allocation and Fiscal Commission and others against Ajibola Johnson, and that the respondents were offered appointment by Revenue Mobilization
Let's maybe that one save the read now.
from the new government that all appointments made in May 1999 stopped. In view of this development, the National Revenue Mobilization Allocation and Fiscal Commission through the respondent respective appointments. Can you please off your mic? Can you mute your mic, please? Can you mute the mic, please? In view of this development, the National Revenue Mobilization Allocation and Fiscal Commission withdrew the respondent respective appointments. The respondent thereafter instituted an action at the Federal High Court claiming that they remain employees of Revenue Mobilization and Fiscal Commission and were entitled to their salaries from 1st June 1999. The Federal High Court granted only the second relief and dismissed the rest of the relief sought. The appellants appealed against this, while the respondents cross-appealed. In its judgment, the Court of Appeal dismissed the appeal and allowed the respondents' appeal in part. On further appeal to the Supreme Court, the issues raised for determination of the Apex Court was whether the Court of Appeal, holding that the appellants were not entitled to the protection afforded by the Public Officers Protection Act. I'll skip it. I'll go to
MP there.
In 2020, the law seemed to revert to one that insists on the limitation law applying to contract of services. And I cited the Abba against Abrahman NNPC, and then also I cited the government of Nigeria against Zebra by His Lordship. I'll go to the holder. Following the foregoing, I find no merit in this application that this lacks merit, and it is hereby, the preliminary objection raised is hereby dismissed accordingly. In this instant case, the suit of the claimant alleges termination of the appointment, which accrued on the 23rd day of August 2009. Permanent injury occurred in the course of his employment with first defendant on the 2nd day of October 2008, or thereabout. Defamation of character, which occurred on the 23rd day of August 2009, or thereabout. And this was on the 4th day of November 2015, which is glaringly outside the time frame of the 5-year period circumscribed by Section 16 of the Limitation Law of the River State. In view of the decision of the Supreme Court in the case of National Revenue Mobilization Allocation and Fiscal Commission and 2 others against Ajibola Johnson and 10 others, the claim of the claimant relating to contract of employment of the claimant with the first defendant is not statute barred, and I so hope. However, the claims of the claimant relating to bodily permanent injury in the course of employment of the first defendant and defamation of character are statute barred. This is also the decision in Honorable Rui Khan JP and others against Commissioner of Justice River State and the case of HD Another judicial claim of the claim. The question whether this court has jurisdiction over defamation in particular and not in general has been a vexed one. Earlier decision of this court held that this court does not have jurisdiction over defamation, even if it arises from the workplace. Naturally, the Court of Appeal has been approached to make a determination in that regard. Unfortunately, the decision of the Court of Appeal has oscillated in that regard. One against University of Alabama and Bisong against University of Pakistan, respectively. The Court of Appeal affirmed the decision of Obaseki Osai J, the National Industrial Court of Nigeria, that this court does not have jurisdiction over tort of defamation. And in the case of Medical and Health Workers Union of Nigeria against Dr. Alfred, unreported, the judgment of which was delivered on 4th May 2016, the Court of Appeal Benin Division by His Lordship Oniyangi JCA affirmed the decision of the Edo State High Court sitting in Benin City, which held that jurisdiction over defamation lies at the High Court and not the National Industrial Court of Nigeria. Because this is 2018 Court of Appeal decision, and the rule that in the event of conflict, the most recent of the conflicting decision of an appellate court is to be preferred. This court has to hold in succeed in cases that it has jurisdiction over defamation. However, the Court of Appeal appears to have reiterated, and so in the case of Ecobank Nigeria Limited and others against Idris, a 2021 case held that the National Industrial Court does not have jurisdiction. As per the dictum of my Lord, His Lordship Said Tanko Hussein JC. I also cited the case of Adeni Olushola and others against Ados Yakub, where it was held that the National Industrial Court does not have jurisdiction over malicious prosecution. All this Court of Appeal the same time, the 2018 decision in the case of Medical and Health Workers Union against Alfred. And so by the law of this court is compelled to follow them. This means that this court cannot exercise jurisdiction over the claim of the claimant that borders on defamation in the instant suit. That being so, Relief 4 cannot be litigated in this court, and I so hold. Flowing from the foregoing, issue 1 is resolved partly in favor of the defendants, while holding that the suit of the claimant relating to termination of appointment is not statutory, while the suit of the claimant relating to permanent bodily injury in the course of his employment with the first defendant, defamation of character as statutory, having been brought after 5 years period allowed by the limitation law of River State, and that the court does not have jurisdiction to entertain the claims of defamation. Therefore, issue 1 is hereby partly resolved in favor of the claimant, while issue 4 cannot be litigated in this court for lack of jurisdiction. I shall now proceed to issue 2, which borders on the termination of the claimant's employment. The claimant pleaded at paragraph 34 of his statement of fact and evidence in chief that the first defendant, without hearing from him, went ahead and made a publication that the claimant employment is terminated on the basis that he stole the said 6 jerrycans of diesel from the company's premises. The defendant pleaded at paragraph 7 of the amended statement of defense that the claimant was caught with jerrycans by the security guard, and not that the guard brought the jerrycans which he accused the claimant of attempted stealing of diesel. Nothing was done to the claimant by the suspicion, and his services were not sufficient, other than that his employment was no more needed by the first defendant. This abatement, as set out here, was not so. Pleading and evidence are distinct species establishing a fact before a court of law. To be adjudged to have established a fact, there must be pleading vis-a-vis evidence in which the two must tilt towards establishing such a material fact. That is the position of the law. Pleadings do not constitute evidence. Thus, where a defendant does not give evidence in support of his pleadings or in challenge of the evidence of the plaintiff, he will be deemed to have accepted and rested his case on the facts adduced by the plaintiff, notwithstanding his general traverse. In other words, an abatement in pleading on which no evidence is adduced is deemed to have been abandoned as a mere abatement without proof of facts pleaded. It does not constitute proof of facts unless such facts are admitted. See the case of Ifeta against Shell Petroleum Nigeria Company Limited, where a party fails to adduce evidence in support of his assertion it is pleading. He is deemed to have abandoned his pleading on that fact. See the case of Eya against Olopad. In the instant case, failure of the defendants to adduce evidence that the claimant's services were terminated because evidence that the claimant's services were not terminated because of the suspicion, other than that his employment was no more needed by the first defendant, means that the pleading of the defendants in that regard has been abandoned. In the absence of evidence in support of the pleading of the defendants, the court will deem the claimants to approve his case. That being said, the law is that an employer who has an employee has the corresponding right to fire him at any time, insofar as that is done within the 4 walls of the contract of service. The employee has no redress. Also, an employee can at any time terminate or determine the contract of employment between him and his employer. And so far as that is done within the terms of the employment, the employer has no remedy in law. The only situation where a bad party to a contract of employment can successfully seek remedy in a court of law is when the terms of employment are breached. See the case of Arinze against First Bank of Nigeria Limited. In this case, there is no terms of employment established before this court by any of the parties. The claimant, having established that his employment with the first defendant was terminated on the basis of allegation of attempting to steal 6 jerry cans of diesel, the defendant shouldered the responsibility to prove that the claimant was caught attempting to steal 6 jerry cans of diesel. And it is for that reason that the employment of the claimant with the first defendant was terminated. Though employer is not bound to give reasons for terminating the appointment of his employee. But if he dares, he must give reasons. However, where the employer gives reason for the termination, the onus lies on the employer to establish the reason stated. See Apri Bank Nigeria PLC against Sisoyin. It is hereby the finding of this court that the termination of the employment of the claimant of the first defendant on the basis of attempting to steal 6 jerry cans of diesel is wrongful, because the defendants failed to prove the reason given for the termination of the employment of the claimant. View of that, C2 is resolved in favor of the claimant, and the claimant is entitled to the relief funds. Though the claimant asks for the payment of his salary from the month of termination to the month when the judgment of this court is delivered, relief 2 of the claimant is a figment of the imagination of the claimant. What the claimant is entitled to, having found by this court that the termination of his employment is lawful, is the salary for the length of notice the claimant deserves. In the case of Osisanya against Apri Bank Nigeria PLC, the Supreme Court held that where a contract of employment or service is terminable on notice, and the employee whose employment is terminated has not been served with the requisite notice, what the employee could have earned during the period of notice, the requisite damages the employee is entitled to. The snag in the case of the claimant is that there is no evidence before this court as to the required number of months of notice for the termination of employment of the claimant. Thus, the court cannot award or pronounce what is not before it. On its utility borders on permanent the claimant pleaded that welcome to put instruction that is to the and is leading to cause the lapse from granted claimant of fragments of his capacity.
Even that papa will always come by here, go buy for that guy and 9,000. The father was why you buy cement?
Oh. Let's hope there. Same with the The crack.
Don't take up because they come out sequence of 1515. Now according to how 1,000, you get 500. They're gonna be 1,000. They have to put 1 week. What is for a week? When I start, but no salary staff like again.
It download download makala ahụ akpago
That one card, sir.
Yes, we're having a talk challenges. I'll just go to the last page. Can you hear me?
Yes, I can hear you.
Yes, we're having a talk challenges. I'll just go to the last part. The finding of this court shows that the employment of the claimant was terminated on the ground of alleged attempt by the claimant to steal 6 jerrycans of diesel in the premises of the first defendant. The claimant does not ask for damages for wrongful termination of his employment, and granting damages without being asked for will make this court looks like a Father Christmas who doles out gifts to children in celebration of the Christmas without asking for it. The court is not about the Christmas and will not give to the parties what they have not prayed for. See the case of Ize Dowin against Union Bank Nigeria PLC. In view of the foregoing issues I enumerated have been issued, the court hereby grants relief 1 and refuses relief 2, 3, and 4 accordingly, and judgment is hereby entered accordingly. So you will get the judgment.
Hello, thank you very much.
Okay. Yes, Council, just give me 2 minutes. I will write the ruling and then